Ladies and gentlemen, you usually indulge me on the last day by enabling me to make some reflections upon the papers that we've heard. They are, I emphasise, only reflections because the papers speak for themselves, and all of them were illuminated by fresh thought and a great deal of intelligent consideration. If I can just add a couple of footnotes to what George said, and in respect of Sir Robert Menzies' approach to the issue, that period came very much to mind in a case that the High Court decided when I was a member of it, the case of Thomas and Mowbray. And I had never questioned the Communist Party case. It was taken at the university as a foregone conclusion that the High Court was completely correct in striking down the Menzies legislation. I think that was partly because nobody paid the attention that should have been paid to the dissenting judgment of Sir John Latham. George, as a factual footnote to your excellent paper, if I might say, it is another factor that Clement Attlee, the British Prime Minister, became aware, once he became aware that the Soviet Union had the atomic bomb, he, with the insistence of Bevan, who had been head of the Transport Workers Union, the most powerful and most numerous union in Britain, insisted that Britain should have the atomic bomb too, so that there would be two Western Allied powers who could match the might of the Soviet Union. But getting back to the Menzies era and the Communist Party case, when Thomas and Mowbray came up, I reflected upon it. I read all the judgments very carefully in the Communist Party case, and I formed the view that if I was sitting on it, armed with the knowledge that we now have, I would have been certainly with Sir John Latham. I wouldn't normally disclose private conversations with other members of the court because conventionally they should be kept confidential. I remember Michael Kirby coming to see me. I always had cordial relations with Michael, as I did with all of my colleagues. But Michael came to see me after I circulated my draft judgment, and he said, "Callinan," he said, "in all my years since I was a student at the university, I never thought I'd ever see anybody question the Communist Party case." And I said to Michael, "Michael, you better read Latham's judgment again." In any event, you will see if you have an idle few moments and nothing better to do. In fact, if you can't get to sleep at night, you might have a look at Michael's judgment and my judgment in Thomas and Mowbray, and you will see that I did indeed question the correctness of the Communist Party case. It's interesting because if you look at the case, you look at the report in the Commonwealth Law Reports, usually the argument is very well reported there, but it seems to be apparent that counsel for the Commonwealth, I think it was Sir Garfield Barwick, who represented the Commonwealth, seemed content to rely upon the recitals to the legislation rather than upon any factual issues. And Latham went into the facts very deeply, and he referred, I think, in his judgment to the Berlin airlift. But in any event, the point is that the court, Sir Owen Dixon, I thought was rather naive in his attitude to international affairs, whereas Sir John Latham was very well aware of them. Of course, he nearly became Prime Minister at one stage, Latham, and he'd served as a naval lieutenant in intelligence in the First World War. And he'd also been present at the Versailles peace conferences after the First World War. So he was very, very much a man of public affairs, whereas Sir Owen Dixon, apart from his period as minister to Washington during the war, had been removed from public affairs, well and truly removed. In any event, ladies and gentlemen, those are really some additional facts, and George will correct me if I'm wrong. Perhaps I'll just add one thing. There was a book published recently, I think it was by a member of the Aaron family, who were communists, intergenerational communists, and one of them spilled the beans, as it were. He said that regularly suitcases full of money would come to the household to be used by the Communist Party for various purposes, designed, of course, to undermine our democratic system and to replace it with a Communist Party one. But I hadn't meant to go into that sort of detail about the matter, but George, you have provoked that by your very thoughtful paper and the deep research that's gone into it. Ladies and gentlemen, we've heard a great deal during this conference, and that's not unusual with this society, about judicial activism. Again, that's a matter that I've had to reflect upon it in more detail than I do during the normal weekday. But looking back, it occurs to me that the period from about 1985 to 1995 was a decade of judicial activism, really very serious judicial activism, which is going to be difficult to reverse. It starts, I think, with the Tasmanian Dam case. The Tasmanian Dam case was decided upon the basis, really, that the external affairs power extended or enabled the Commonwealth to impose the ban that it did upon the construction of a hydroelectricity plant on the Franklin River in Tasmania. And it was argued successfully, that environmental affairs were a matter of international concern, and therefore the Commonwealth could legislate as it did. Now, if you look at the implications of that, they are that if anything is a matter of international concern, it can be used for a hook, used as a hook upon which to suspend any sort of Commonwealth power that you might wish to exercise. And that really means that's got a very serious political implication. And that political implication is that Conservative parties in Australia, if they get into power, have to be extremely cautious about the international instruments to which they sign up to. And we have a great high habit of signing up to international instruments. One of the instruments that we have signed up to is an international convention on Indigenous affairs or Indigenous people. I don't think it's been enacted into law yet, but if, for example, Tio's case is revived, and I think it's a real possibility that it may be by the current High Court, but if the Tio's case is revived, it will mean that you don't really have to enact these things into law, that for the purposes of administrative law, the decision maker should take into account that the executive government has committed Australia to some international obligation. Now, politicians speak freely of international obligations, but it needs to be understood that all international obligations are assumed voluntarily. We self-impose them upon ourselves. My view is, for what it's worth, that in view of the atrocities of October the 7th and the activities of the International Criminal Court, we should withdraw from it. I think I think that we can do that by giving 12 months' notice. Well, we should give it straight away. But I don't have any claims to be prophetic, but I remember a conversation that I had with John Heron, who was a friend of mine, and a very capable minister, a very capable person in many respects. He was a leading surgeon. And I was at a function, and John raised the question of the International Criminal Court. And he said to me, "What do you think about Australia going into it?" And I said, "John, don't touch it." I said, "You will find that the people in the dock will almost certainly be from Western democracies rather than from any other countries." And just incidentally, his wife Jan said to me, "Yes, you tell him that, Ian, I'm telling it." But John, in the end, I know, supported Alexander Downer in the debate, which we now know was quite a heated one in Cabinet about whether Australia should go in or not. But returning to the decade about which I'm speaking, we had Tio's case in which we had not signed up to a particular covenant. We had signed up to an international instrument. It was an international instrument for the protection of children. But it had not been enacted into law. The High Court held in that case that although we hadn't signed up to it, although we'd signed up to it, we hadn't enacted it into law, the decision maker should have taken it into account in deciding that a convicted drug dealer should be deported to the country in which he was born. He was an illegal entrant to Australia, because it hadn't been taken into account that he had 2 or 3 children in Australia. Now, they were the only factual components in the High Court's decision of any real relevance. When the issue came before us, we didn't specifically or expressly overrule it, but in a case called Lamb, that's after the decade of activism, we reached a different conclusion, and I was critical of Tio in it. So that's another case during that period. But I also wanted to say something about Mabo. If there's one additional thing that the referendum showed that I don't think has been talked about at the conference, it's that now we are willing to have a debate about race in this country and how we can improve the lot of Aboriginal people in a really constructive way, and what our laws need to be in relation to that matter. Now, that was a topic. Well, race and religion, both tinderbox topics, but that was a topic upon which everybody in Australia felt very sensitive about. And Australia had some reason to feel sensitive about it. We had a White Australia policy for a very long time, and certainly in some respects about some countries we were xenophobic. But I think that after the referendum in 1968 in relation to Indigenous people, we had no reason to feel guilty, because current generations, that generation and the generations today, all I think have very good intentions and wish for constructive improvement of Aboriginal affairs. So that means the fact until the referendum, nobody questioned really Mabo. Now, I want to come back to Mabo and just mention the case of Longy, which is very much a case, I think, of activism. In Longy, you'll recollect, the High Court invented an implied freedom of political discourse. Now, there'd been previous cases which showed that it was coming. In fact, Justice Toohey, I think, 2 or 3 or 4 years before, made a speech in the Northern Territory which really invited an application or a case to be brought to try to that might have the effect of causing such an implication to be made. But in any event, in Longy, the High Court held that there should be, and there was, an implied freedom of political discourse. Now, because it's implied, it's not written anywhere like the Constitution, so it's going to be expanded, it's going to be, as the invention, it's almost as if the court has patented it. It means it's always going to be in the control of the court, and that there's never going to be any set of words in the foundational document which will limit it. But the basis, one of the principal bases upon which the court purported to found such an implication was the text and structure of the Constitution. Now, if I can go back to Mabo decided, you'll recollect, that land that had not been alienated by the Crown was land that, I'll use this word, maybe something of an overstatement, but was land that was ripe for consideration as being native title land. The High Court also held that the title would not go to any individual person. It would go to a group or a clan. I think they're the expressions. So, and the High Court didn't lay down any rules as to how any boundaries would be drawn between native title land and other land, or as to how any boundaries would be drawn between the land claimed by 2 clans or two groups. So there was a great deal left up in the air. But what should have been done? What could be done after Mabo was decided? In a sense, Mabo blindsided the Australian public. I don't think anybody really saw it coming, and they didn't see coming what a comprehensive and uncertain and what a decision it would be, or what an impact it would have upon property rights in Australia. What I'm putting up now is a what-if question. What if the argument had been foreseen or anticipated? What if a submission had been made that on federation in 1901, the text and structure of the Constitution was such that it was clear that the states would have full and absolute control of all land within the state. That the notion that there might be some other form of title not ever thought about before, not mentioned in the convention debates, would suddenly emerge, would be unthinkable. Now, if you can look only at the text and structure of a constitution, might you not have said, or could you say, and I'm not suggesting anybody would advance this argument in the High Court, because it would have the same chance as a piece of confetti in a tempest of succeeding. But why would one not say that the distribution of powers under Section 51 mean that states entirely have control of land, and that the states, as in from 1901, whatever uncertainty there might ever have otherwise been, and I don't think there was any doubt that our system of land titles was very certain in 1901, that nothing could be done to add some different form of title unless a state chose to do so. That this was not a power, and there's no suggestion in Mabo, of course, that this is a Commonwealth power that's being exercised, but that this just isn't. That there isn't room for any other sort of title than the sorts of title that have been developed and refined by common law and statute over hundreds of years. In any event, we're stuck with Mabo. I don't think there's any chance of overruling it or modifying it in the future. Was there a political response that could have been given to it? Perhaps there was. Nothing I'm saying is to suggest that there may not have been a very strong moral case for some sort of reparations for Indigenous people. But had those reparations been agreed there and then, for example, by, say, the establishment of a future fund, not to be distributed for 10 years, and in those 10 years, the actual manner of distribution could have been worked out. But the response wasn't that. We got the Native Title Act, and it was rather, I wouldn't say, would be an overstatement to describe it as unleashing the dogs of war, but it certainly unleashed the dogs of lawfare, rather, because some of these claims take 10 to 15 years to work out. And even then, there's often a great deal of uncertainty. But the next question is, I suppose, are we about to embark on a further period of legal activism? I'm inclined to think we are. There's no need for me to say anything further about Love and Peacock. It was an astonishing decision, and I also think the decision last year that resulted in the release of 150 people who were illegally in this country, stateless people. I think that is an example of judicial activism, and I foresee more of it in the future. Ladies and gentlemen, I would not want to detain you any longer. You've been given, I think, an extraordinarily profound and thought-provoking series of talks, and anything further that I would say would be superfluous. Thank you for your attendance, and thank you for the courtesy of listening to me today in my sign-off interview. Thank you.
Well, thank you, Judge, and again, on behalf of the Society, let me once again note our deep thanks and admiration towards you for not only your long service of the Society, but also your long and great service and contribution to the nation and public life. It's been a privilege to be able to serve as Executive Director under your tenure, and we look forward to continuing to honour and celebrate the Judge over the next year, culminating with our conference next year, and also to continue to have your involvement and membership of the Society as Emeritus President. So with that, our proceedings end. Lunch is about to be served outside in the foyer for those who wish to stay and join us. For those who are heading off back home, safe travels and see you again soon. Thank you, everyone.